The special counsel completed his work and submitted his final confidential report on January 7th, 2025, and separated from the department on January 10th. Bye, Jack! There can be no serious question that Garland had at minimum the statutory to hire Jack Smith and his staff as employees. Yeah, but he didn't! He didn't do that! He was illegally appointed and he was not hired as an employee by their own arguments, right? They made that argument multiple times. Jack Smith is gone. He resigned very quietly and pathetically in a footnote and is now fleeing the DOJ, probably after he shredded all of his files. And now the DOJ is still trying to finagle the release of his report, which we'll talk about. Judge Cannon is doing some interesting things on that. But Trump is celebrating Jack's pathetic departure. The illegal prosecutor is gone. Trump says about Jack, the stench of deranged Jack Smith and his thugs is gone. They were sent packing after spending over $100 million, destroying the lives of many people and families who will never be the same again. Deranged Jack accomplished nothing except to show what complete losers my political opponents are. Jack, Brat, Molly, Gaston, Highlighter Girl, and the rest of them who weaponized the DOJ to try to take Trump out literally and throw him in jail so that he could not be a part of the campaign. They failed, and now Jack is running scared. Trump also posted this, says deranged Jack was fired today by the DOJ. He is a disgrace to himself, his family, and his country. After spending over $100 million on the witch hunt against Trump, he left town empty-handed. No convictions, 2 dismissals in both cases, and a good argument that the special counsel was illegitimate from the beginning, and he stole $100 million that I hope Trump investigates. Illegally apportioned money ripped off from the government to prosecute a political opponent. I hope every dollar is accounted for and scraped back. But that will never happen, but we do want accountability. So Jack is now gone, and let me show you what's happening in the court filings, because even Politico is calling this, saying Jack Smith ends with a footnote. Pathetic. This is from the government's response right here at the bottom. After the conclusion, after the new attorney, Elizabeth Shapiro, comes in, all the way tucked down here in this little loser footnote on page 10 of their filing. It says here, the special counsel completed his work and submitted his final confidential report on January 7th, 2025, and separated from the department on January 10th. Bye, Jack! That's all you get in a footnote 3 on page 11 after the conclusion? Pathetic. He completed his work, submitted his report. Now he's going back to The Hague over there in Europe. Nobody wants him here or there either. So this confidential report must be done so there can be no changes done to this thing. And what's so funny about this is now that Jack Smith is gone, watch this. The Senate Judiciary Democrats posted this. They said, oh, guess what? Now Senate Judiciary Democrats are pressing Merrick Garland to preserve all of his records related to Jack Smith and to President Trump. It's like, what? He just left. The shredder van just pulled away like 2 minutes ago. Where were you 10 minutes ago before the shredder van arrived? Hello? Yeah, we want all the documents too. We want all the emails. We want all emails that went back and forth between Senate Judiciary Democrats and anybody even remotely connected to this investigation. On Jack's team, we know Fannie may have had emails. We want those. We know Tish may have had emails. We want those too. We want everything. So don't come out here and pretend, Democrats, like you're on the side of transparency and accountability when you people have been exploiting him for the last several years. So here's what Trump's people said. You should extend your stay, the injunction that would prohibit Jack Smith from releasing his book reports. Stop those from coming out because Jack Smith is disqualified and you have the right to do that. The government minimizes your role, Judge Cannon, in overseeing its own trials and your words. And Judge Cannon said Jack Smith is not a real boy and threw him out. The relief requested is not contrary to the law, but rather consistent with long-standing practice. It's also consistent with principles of equity, not that kind of equity, okay? In the law, before they perverted that word, being equitable used to actually mean something. Now it means that everything gets worse or something. Now the government, driven by political priorities that have no place in a criminal trial, talking about illegitimate Jack, seeks to strong-arm its way through this orderly process. And this court, you, Judge Cannon, should enforce your order. You said Jack Smith was not a real boy, and so you better make that have some teeth to it. Now they're trying to view this as a political inconvenience and saying Jack has every right to give Garland the book report. So they say, Cannon, you have jurisdiction to maintain the status quo and to enforce the conduct that is going to taint this trial. The government's position is that the mere filing of a notice divests this court of jurisdiction to enforce its own orders. They say that's obviously a problem here. You said Jack is not a real boy. Now he's acting like he is a real boy. So do your your words matter or not? And temporary orders like this one are also subject to appeal. And so the government is misstating and misrepresenting the law, saying that you don't have any jurisdiction here. They cite Coinbase on referencing interlocutory appeals, which is a very common case. We've talked about it a lot here. But they say the merits of Trump, Walt, and Carlos's request for emergency relief are not an issue in the appeal. The only question is about the injunction. And the court did not enter the injunction on the merits of the request. It was temporary while we were appealing to the 11th Circuit. And so you can and you should do this. The government attempts to litigate the merits of this dispute, but we're not doing that here. We've got several bases to restrict AG's release of this. The most significant of them is that if they release the report on Trump from Jack's fake office, it could impact a fair trial for these two continuing co-defendants. An extension of the stay here would allow us to continue to litigate this. The government is talking about what the Attorney General can do and whether Jack is a subordinate official to him, but it cannot be deemed concluded because this court disqualified Jack from the very case. All this stuff that he's saying he has the power to do and can do, and Merrick Garland and all these stuff, it's irrelevant. He's not a real boy. Nor, although the special counsel resigned, the matter is not concluded. The appeal was filed and it was briefed by Jack. It still continues. And to the extent to which the former or disqualified counsel is still operating, the defendants are still under the protective order of the court. So if they're still under the jurisdiction of the court as it relates to their protective order, in other words, if Carlos and Walt can't say or do certain things, this court still has jurisdiction over them. So why wouldn't it have jurisdiction over Jack? Another reason that the government cannot rely on this portion of the law is because he was also unlawfully appointed. The final report was prepared unlawfully after you found he was already unconstitutional. And so it is a legal nullity under a binding order of dismissal from you, Judge Cannon. And as a result, all of this is not subject to that provision. There's no obligation to release the report. Merrick Garland is authorized to do so. He's not authorized to do so because his prosecutor who wrote it was illegal. Now, the DOJ seeks to ignore this court and you, Judge Cannon. And worse yet, they're trying to exploit a loophole by claiming that because Jack was disqualified from the case, his investigation concluded and referred it to a local office. Now, this case presents an unprecedented scenario of an attempted release to Congress while the case is still going. There's a lot of litigation to be concluded. We are up in the 11th Circuit right now. So such a scenario is not contemplated. Now, the government asserts that whether the case will ever proceed is presently uncertain. Now, it's nice that they're saying that right now. And while we view this court's order of dismissal as the correct reading of the law, the mere fact of an appeal means that this could be reversed and there's prejudice. So the government also overstates their middle ground. Their proposal removes judicial oversight over the flow of publicity. Remember, Jack just wants to give this to the senators in the Judiciary Committee to allow them to leak it. So they won't publish it because, oh, if the DOJ publishes it, then it would harm Walt and Carlos, the two other co-defendants. But if senators leak it, then I guess that's better because that won't harm them as much. The DOJ seeks to pillory these criminal defendants, and the proposed parameters are unclear. They say, what? What are the restrictions on members of Congress who can review it? Can they publish it? Where is the government's in-camera review going to occur? Is it going to be in Jack's office or in Congress? Are members permitted to talk about it? Are they permitted to discuss the case at all now that they've seen the confidential parts of it? Are they permitted to disclose their reactions? Can they talk about and wage war against them for fundraising like Judge Mercan's daughter did? Does public discussion of the report relieve the defense of their protective order? Are they still gagged, or can they also talk about whatever they want? If this case is going to be tried in the court of public opinion, is the defense not at least entitled to an adversary process in that forum? All these questions warrant consideration. We need a hearing. A hearing will ensure that our due process rights are properly considered. And Judge, as the defense noted before, there is no way for this court to bind members of Congress. You can't do that. Nor does the government propose any assurances to insulate against the leaks, which are obviously going to happen. So Congress is a political body, right? And its individual members have political aims. And this is a political case. So the government's claim that disclosure to Congress is a safeguard is obviously not true. This is an era in which a draft of a Supreme Court decision on abortion was leaked. The functioning of the political press demands and depends on leaks. And if these leaks occur here, our defendants have no recourse. Members of the judiciary in the House are not entitled to access in a pending criminal case, especially not privileged in grand jury materials. So there's no reason to provide that here. Any access must only be provided after a court process, due process, remember, and a hearing, not unilaterally by the DOJ when they want to just publish something to Congress. The government's response illustrates the need for this court to pass a stay, and you need to stop the release of both of these volumes. In response to this court's order, the government says, Volume 1 does not concern this prosecution. Volume 1 is the J6 case. Volume 2 is the Florida Classified Documents case. case. They say they're separate. Trump defense says, no, they're not. They reference each other and they're commingled to a degree that you cannot disambiguate them. They say that is non-responsive. The question was whether Volume 1 directly or indirectly refers, relies, or bears in any respect upon any evidence or argument related to the charges, and whether understood liberally it contains any of the foregoing. Are they referencing each other? Are they commingled? The government has set forth only what appear to be the most formal articulations of Volume 1's reference to Volume 2. Those references were deemed significant to Jack, and a review of the entirety of Volume 1 is expected to reveal the full interrelatedness of grand jury testimony, witness attacks by the government, conspiracy, and other criminal theories for which Jack sought to vouch for in the report. The protective order principle applies fully where the government seeks to try this case in a court of public opinion. A figure as a co-conspirator in this case, the government has sought far more reaching gag orders than anything here. Now, what they're not telling you, Judge Cannon, what they're not disclosing, either in its public filings or in its sealed supplement, who reviewed Volume 1, what the person who reviewed Volume 1 knows about the sealed or even unsealed proceedings in this case, what standards of evaluations were used to support this belief of the United States. Now, this is amplified by the fact that 3 attorneys, 2 of them civil lawyers, who signed the government's brief are brand new to the case, and they're not familiar with the facts or nuances. Jack's office is gone, so they threw these newbies on. The attorneys asserting no connection do not know the significance of certain matters in their report. They don't understand the connections between the 2 cases. They don't have a well-versed understanding of the evidence. There is anticipated overlap between the witnesses and the 2 cases, and the facts and circumstances are inextricably intertwined insofar as the conduct targeted in both investigations was around the same time involving the same people. And so that evidence would not be admissible in Walt Nauda's trial, and it would taint the jury pool. So the significant overlap between the 2 cases, both temporally, in time, and with respect to witnesses and evidence, combined warrants an independent review of Volume 1. Do not release that either. Now, counsel can proffer that Volume 2, so the attorneys for the defense say, we've read it. We know Volume 1 is referenced in Volume 2. So when Jack's talking about Florida, he's also hearkening back to J6. The report has a coordinated message and intent to the best of counsel's understanding. Now, the government invites this court to review Volume 1 in ex parte fashion, so on your own, Judge. But that request is inconsistent with due process. The government is saying, you look at it. But that's inconsistent with our adversarial system. The defense, too, should be permitted to examine Volume 1. The government has it. They're showing it to you, Judge, and they don't want us to see it. That's ridiculous. We should see it. We should be able to lodge sealed objections to be dealt with in a sealed hearing. Ex parte applications are disfavored when only the judge meets with one side because a fair hearing requires a reasonable opportunity to the opposite side. And the government has not offered any argument to support its ex parte review of Volume 1, the J6 case. Again, it's attempting to avoid the adversarial process in the interest of politics. There's no prejudice that would result by allowing us to look at it. We're not going to release anything. We could have a sealed proceeding. There is no reason to block the defense from the process, but the government just wants to publicly release it. There's no harm to them if we have an opportunity to review. So they say the Trump defense and team, they request that the court stay its expiration. Do not allow the report to be released moving forward and hold a hearing signed by Stanley Woodward, who's going in as counsel to the White House in some fashion over there on behalf of Carlos and Walt. So you can see this is what the government sent. They say, Your Honor, you have to release this report. There's 2 volumes here, okay? Volume 1 is about J6 in 2020. Volume 2 is about the classified documents. They say, you don't have any jurisdiction, Judge Cannon. Okay, sorry. You can't release this even if you wanted to. The court is prohibited from hearing this motion, and there's no jurisdiction here because we're up at the 11th Circuit and they're handling this case right now. But in addition to the jurisdiction argument, you have to release this anyways. An extended injunction without basis on Garland's prerogative, he can manage the DOJ. And he got a report that was prepared by a subordinate. And so he's allowed to release that. The laws say that he can determine that in public interest, we need to release this, and the injunction doesn't give you the power to stop it. Now, they speculate that the department is going to violate or leak this stuff. They say it's ridiculous. We're taking precautions, says the DOJ. We're going to put an in-camera review of the document to 4 members of Congress and allow them to review it. This argument is resting on conjecture, saying that they'll leak it. These are esteemed members of Congress. Why would they do anything like that? There's no case that they can cite where that concern that Congress is going to be leaky prohibits the disclosure. And so an extended injunction to stop the release is even less warranted. Merrick Garland has already determined that he's going to release Volume 1 1. That volume is about the election. They say they identify no Article 3 standing issue that would justify not releasing this because they don't have any claim in the other case. And this holds true even if this court were to grant Trump's motion to intervene, because he doesn't have any basis to block Volume 1 either. None of the arguments raised would prejudice them. Trump is no longer a defendant. Okay, they dismissed him from the case. And even if Trump had colorable grounds for blocking 1, there's still no basis for allowing him to do that. Beyond the now allayed concerns of prejudice, there's no basis for allowing this. And even if Jack were invalidly appointed, it would still not follow that the report was improper. What? There can be no serious question that Garland had at minimum the statutory to hire Jack Smith and his staff as employees. Yeah, but he didn't. He didn't do that. Okay? If he would have done that, this whole thing would have been different. The Supreme Court has recognized that investigative reports can be prepared. There is, therefore, no appointments-based reason to doubt his authority to draft a report, much less prevent him. Yes, there is. What a stupid paragraph this is. He was illegally appointed and he was not hired as an employee by their own arguments, right? They made that argument multiple times, saying that Jack Smith falls into the certain category and he's got power appointed by the Reno regs. The Attorney General, in the Senate-confirmed head of the Department of Justice, is vested with authority to supervise everybody. Okay, that's great. He can supervise officers. Jack is not one of them. He can supervise employees. Jack Smith is not one of them. The Attorney General thus has the authority to decide whether to release a report prepared by his subordinates. Jack is illegal. He never was one of those. That authority is inherent under the law. Sure, he has that power if he has actual employees working under him. So their objection to his appointment has no bearing on his authority. Yes, it does. This is ridiculous. The court should reject their request for a hearing. As explained above, this court lacks jurisdiction, and that reason alone should be enough to deny this continual injunction. And so in conclusion, do not make us continue to hold this report back. We want to release it, especially Volume 1 of the final report. And then once again, after all of that was written, they came back and Jack got sent off into the pasture in a tiny, pathetic little footnote right there. So Elizabeth Shapiro sent that one out, and that went into Judge Cannon. Obviously, the argument that people anywhere can write reports. Like I can write a report, send it to Merrick Garland, and he can just take it because he's got authority to do it. Even if you're not a lawfully appointed prosecutor or a hired employee. That's how it works, apparently. And Judge Cannon came back and issued her order. Judge Cannon, Southern District of Florida, now allowing portions of Jack Smith's report, Volume 1, to go out. Volume 2, she wants to hear more. But here's what she released. This is an order denying the emergency motion that would stop the J6 2020 report from coming out. Here's what Cannon writes. This cause came before me. We got a bunch of people filing stuff. The emergency motion seeks to stop the entirety of Jack Smith's final report from coming out. And Cannon, you can see she has capitalized final report, and for a while she was bundling them together. Then Jack very conveniently, Volume 1 did and Volume 2 did, so he could bifurcate the two to release one, because he knew that he was in trouble on the Florida case. So she tells us, as described by the United States in its filings, Volume 1 is the J6 case, election interference, and Volume 2 is this case, the classified documents case, which is the subject of this court's order granting the motion to dismiss based on Jack Smith's illegality. She said, I dumped this case because he's not a real boy. Now, the United States, DOJ and Jack, who's not there anymore, opposes any restriction on the release of Volume 1. They want that to go out publicly, and I imagine it's coming soon. And they agree that Volume 2 should not be released to the public because it concerns the ongoing legal rights of Walt and Carlos. But nevertheless, they seek permission to release a limited amount of Volume 2 to specified members of Congress because they say Congress is very curious about this. And so here's what Cannon says. The emergency motion is denied as to Volume 1. So we can no longer hold that back. The United States represents, and she's quoting them, that it believes that nothing in Volume 1 of the final report directly or indirectly refers, relies, or bears in any respect upon any evidence or argument related to any of the individual charges in the Florida case. Now she's quoting them, right? See that right there? So you guys are representing it. Cannon saying, I have not read it yet, but you're telling me it's got nothing to do with the other report. The United States further indicates in the same filing and reiterates in a sealed addendum that we cannot see. She says some of that she'll show us. She says that Volume 1, according to the government, makes two generalized references to this criminal case. So actually Volume 1 does reference Volume 2, but it doesn't reference the names Nada or De Oliveira, and it doesn't address any conduct by them, evidence against them, or the charges against them. So it references it, but not by name. They also said, other than these 2 references, the government says, there are no other references to the classified documents case in volume 1 of the final report. So like that better be true. There better not be another reference in there. There's a 3rd reference in there. Based on these representations, the court sees an insufficient basis to stop the release of Volume 1. The court's order granting the motion to dismiss the indictment based on the appointments clause was confined to this proceeding, right? She didn't dismiss the J6 case. And if the J6 report has nothing to do with the classified documents report, she's saying, I don't have jurisdiction. And hence, this court's authority to enforce its own orders is similarly confined to this proceeding and to the remaining defendants in this proceeding. They also tell us in footnote 1, in a letter submitted by the United States to this court, Jack Smith states as follows. He says, because Volume 2 discusses the conduct of Mr. Trump's alleged co-conspirators in the classified documents case, Walt and Carlos, and consistent with the policy, Volume 2 should not be publicly released while their case remains pending. And I can't believe they haven't dismissed those yet already. But if they did dismiss it against Walt and Carlos, it would just look obvious that they're only doing that to release the report. But here we go. It tells the emergency motion from Cannon as to Volume 2 now presents a contested factual and legal issue that must be resolved in an expedited basis following a full briefing and hearing. All parties agree that Volume 2 expressly and directly concerns this case. All parties also appear to agree that public release of Volume 2 would be inconsistent with the fair trial rights of Walt and Carlos or Justice Department policy. And despite these concerns, the U.S. still seeks limited disclosure of Volume 2. They want to give this to Hakeem Jeffries and Chuck Schumer because they say there are public interests and congressional leadership needs to be apprised. Now, the defense vigorously opposes this request, relying on their due process rights, local Florida rules, and they know that this report is ultimately going to be publicly disseminated and leaked. Now, in light of these contested issues, Judge Cannon says, we need a hearing on this case at the end of the week, January 15th, 17th, Friday, 2 p.m., Fort Pierce Division. Any response to this is due on the 14th and a reply is due on the 16th, and you should let me know if there is an agreement about the release of Volume 2. And so all that will be resolved later in the week. Now, to the extent that counsel for the United States has any doubt about the representations made to this court about the absence of any connection, because these are new attorneys on the Jack Smith team. The team is now gone, right? So they're evaporating. So the DOJ brought on new prosecutors who were not part of the original team. So they're making this avowal to the court. Your Honor, we promise, and we've got a duty of candor to the court, says between Volume 1 and the factual legal issues, they say that there's a belief, right? There's a belief that nothing in Volume 1 relates to this case. You better be damn sure about that. There's a court order requiring specific clarifications. Now, counsel, the judge is warning them, they are reminded of their obligation. Lawyers have a duty of candor to the court. Can't lie or be manipulative or hide things. Got to be open and honest and forthcoming. So if you say that, oh, I believe that there's no reference there, and then we get the report and it's riddled with it, you're in trouble. And their duty as officers of this court to ensure complete accuracy and completeness in their representations. So belief better be pretty dang sure. Now, of course, what is the recourse for this? If the report comes out and it is full, what's Cannon going to do? Maybe she calls them in here, issues an order to show cause. You were dishonest about this. Now you guys get sanctioned, but the report's out. So you can't unring that bell. Now the court is next bound to consider their emergency motion to stop the release of Volume 2. Now on this point, now if we're talking only about Volume 2, the court agrees with the defense. Release of Volume 2, even on a limited basis to hack congresspeople, risks irreversibly and substantially impairing these co-defendants. This court is not willing to make that gamble on a basis of some generalized interest by Congress, at least not without a full briefing and hearing on the subject. Nor has the United States presented any justification to support the suggestion that Volume 2 must be released now, as opposed to after a reasonable hearing that's being expedited, by the way. We're going to do it on Friday. And so for those reasons, the court must enjoin temporarily Garland, the DOJ, officers, agents, employees, and more from releasing Volume 2. Don't release Volume 2. Don't release any drafts or anything until this Friday, the 17th. We're going to have a hearing and then the judge will make a determination thereafter. I mean, the judge is going to need some time to think about this. So hopefully she comes back with her order over the weekend. She gives it a lot of thought and then she can decide what to do on Monday afternoon. Hey, after Trump's inaugurated. All right. So a final word on this jurisdiction, says Cannon. The 11th Circuit January 9th summary denial of Trump's motion contains no directive that I don't have jurisdiction over this. And we're not persuaded by the government that I don't have jurisdiction either. I've got jurisdiction, and so stop saying that. So in light of this order, the court denies stopping Volume 1 from coming out, but allows the stay to continue in Volume 2. Now, Trump, meanwhile, says, why would deranged Jack Smith be allowed to issue a report on a complete and total witch hunt against me, strictly for political purposes, when he was thrown off the case and ultimately dismissed by the DOJ? Therefore, to put it nicely, he was illegitimately involved in this political persecution, and all of the hundreds of millions of dollars spent by our hapless government were, simply put, wasted. He has already filed thousands of rejected statements and documents against me, which were a joke, and the public just voted for me in a landslide to be their president.